Welcome to The Docket. I'm your host, Corey Snow. In this episode, we're going to hear Special Counsel Jack Smith's response, filed August 21, 2023, to a motion made by the Trump defense team to postpone the criminal trial of Donald Trump in Washington, D.C., for attempting to overthrow the 2020 presidential election to 2026. The defendants in any criminal proceedings are presumed innocent until proven guilty in a court of law. United States District Court for the District of Columbia, in re-press application for access to judicial records ancillary to certain grand jury proceedings concerning former President Trump's communications with his attorneys. Miscellaneous number 23-65, JEB. Memorandum Opinion. The legal news cycle has seen lazier summers. In one of many noteworthy events, a federal grand jury indicted former President Donald J. Trump this June for retaining and concealing classified documents after the conclusion of his presidential term. Reporters have since been hard at work, setting vacation plans aside to wade through the lengthy indictment. Having observed that the indictment contains detailed accounts of Trump's discussions with his attorneys, which are normally protected by the attorney-client privilege, a set of news organizations now asks this court to disclose how the government obtained them. Because any such disclosure would infringe on grand jury secrecy, however, the court must deny the request. 1. Background. In November 2022, Attorney General Merrick B. Garland appointed Jack Smith as special counsel to investigate Trump for allegedly moving classified documents out of government hands and to the Mar-a-Lago Club in Palm Beach, Florida. See press release, Department of Justice, Appointment of Special Counsel, November 18, 2022, https://perma.cc/G5K2-ZN7T, Trump v. United States, 54 F. 4th 689 694 296 11th Circuit 2022, describing government's discovery of, quote, over 100 documents marked confidential, secret, or top secret that Trump had not produced in response to a subpoena. That appointment led to a grand jury investigation, which in turn resulted in an indictment. A. March reports of grand jury testimony. In March 2023, some news outlets cited unidentified sources to report that, quote, a federal judge had at least partially granted a request from government prosecutors to force an attorney for Donald Trump to testify before a grand jury, end quote. After, quote, the lawyer, Evan Corcoran, had refused to answer investigators' questions, invoking attorney-client privilege, end quote. Josh Dawsey et al. Judge rules Trump lawyer Corcoran must testify, people familiar say. Washington Post, March 17, 2023, https://perma.cc64se-sfra. See also Catherine Falders et al. Sources: Special counsel claims Trump deliberately misled his attorneys about classified documents, judge wrote. ABC News, March 21, 2023, https://T8YR-P3AE, describing what a, quote, top federal judge wrote Friday in a sealed filing, according to sources who described its contents to ABC News, end quote. Both Corcoran and the special counsel declined requests for comment. See Falders et al. Supra, Dawsey et al. Supra. Trump, meanwhile, stated through a spokesperson that, quote, whenever prosecutors target the attorneys, that's usually a good indication their underlying case is very weak, end quote. That, quote, every American has the right to consult with counsel, end quote, and that he would, quote, fight the Department of Justice on this front and all others that jeopardize fundamental American rights and values, end quote. Dawsey et al. Supra. He also described the reports as unlawful leaks. C. Falders et al. Supra. Quote, in response to ABC News, a Trump campaign spokesperson said in part, "Shame on fake news ABC for broadcasting illegally leaked false allegations from a never-Trump, now former chief judge. The real story here that fake news ABC should be reporting on is that prosecutors only attack lawyers when they have no case." End quote. B. June indictment. Within a few months of those March reports, a grand jury impaneled in the Southern District of Florida returned a 37-count indictment against Trump related to his and co-conspirators' retention of, sharing of, and obstruction of efforts to retrieve classified documents. See United States v. Trump, number 23-80101, Southern District of Florida, June 8, 2023, ECF number 3, indictment. Paragraphs 7, 46 to 47. The indictment details Trump's interactions with 3 unnamed attorneys, identified only as Trump attorneys 1, 2, and 3, through whom Trump sought to, quote, falsely represent to the FBI and grand jury, end quote, that he, quote, did not have the classified documents called for, end quote, by a subpoena and attempted to, quote, hide or destroy, end quote, them instead of handing them over. Ibid, paragraphs 52, 55, 68, 80 to 81. The indictment also summarizes conversations Trump had with his attorneys, quote, as memorialized by Attorney 1, end quote. Ibid, paragraph 54. Attorney 1, the press conjectures, is Corcoran. It so believes because back in 2022, the government filed a brief in the Southern District of Florida to defend its execution of a Mar-a-Lago search warrant and attached to that brief a document identifying Corcoran as having accepted service, just as the indictment states Attorney 1 did. See Ibid, paragraph 52, ECF number 1, Memorandum in Support of Press Application, at 1N1, citing Trump v. United States, number 22-81294, Southern District of Florida, August 30, 2022. ECF number 48-1, Attachment D to Government's Response to Motion for Judicial Oversight, at 14. C. The Press's Application. Matching the March reports of Corcoran's privilege dispute up with the indictment's description of Trump's communications with his attorneys, a press coalition comprising CNN, the New York Times, and the Washington Post has concluded that, quote, the government undoubtedly obtained information about Trump's communications with his attorneys, which ordinarily would have enjoyed protection under the attorney-client privilege, following an adjudication by this court that the government had overcome Trump's putative privilege, end quote. ECF number 1, press application for access to judicial records at 1 and 2. That coalition now moves to access, quote, judicial records concerning any claim of attorney-client privilege or attorney work product protection asserted as to communications between Trump and his attorneys, end quote, with, quote, only those narrow redactions necessary to shield whatever factual material, if any, might still require protection from disclosure, end quote. Ibid at 1 and 3. Because the Chief Judge must, quote, hear and determine all matters relating to proceedings before the grand jury, end quote, the press's application was assigned to this court. See LCVR 40.7b. The government moved to file its opposition under seal. See ECF number 5, motion for leave to file, at 1N1, which the court granted with the caveat that it could later order the government to file a redacted version of its opposition on the public docket. See Minute Order of August 2, 2023. Although the opposition remains sealed, the court cites portions in this opinion that divulge no protected grand jury material. 2. Legal framework. A. Grand jury secrecy. In general, quote, the grand jury context presents an unusual setting where privacy and secrecy are the norm, end quote. In Re Grand Subpoena Judith Miller, 438 F3D 1141 1150, D.C. Circuit 2006, quoting in Re Sealed Case Dow Jones II, 199 F3D 522 526, D.C. Circuit 2000. Witnesses, quote, enter the grand jury room alone. No judge presides and none is present, end quote. In re Motions of Dow Jones and Company, Dow Jones 1, 142 F.3D 496 498, D.C. Circuit, 1998. Access to grand jury materials turns on Federal Rule of Criminal Procedure 6E2, which dictates that, quote, other than witnesses, each person present is forbidden from disclosing matters occurring before the grand jury, end quote. Ibid, quoting Federal Rules of Criminal Procedure 6E2, 6E3A2. See also in re-sealed case number 99-3091, 192 F.3D 995 1002, D.C. Circuit, 1999. In this circuit, courts, too, lack any, quote, inherent authority, end quote, to release matters occurring before the grand jury. McKeever v. Barr, 920 F.3D 842, 844, 850, D.C. Circuit, 2019. This arrangement, quote, safeguards vital interests, end quote, including, quote, 1. Preserving the willingness and candor of witnesses called before the grand jury, 2. Not alerting the target of an investigation who might otherwise flee or interfere with the grand jury, and 3. Preserving the rights of a suspect who might later be exonerated, end quote. Ibid at 844, citing Douglas Oil Company v. Petrol Stops Northwest, 441 U.S. 211219, 1979. B. Accessing ancillary proceedings. The grand jury's business may also call for, quote, judicial proceedings relating to, quote, but, quote, at arm's length, end quote, from that body, including to resolve a grand jury's witness's, quote, motion to quash a subpoena or her invocation of a testimonial privilege, end quote. Dow Jones 1, 142 F.3D at 498. Records of such proceedings ancillary to the grand jury's work are not themselves subject to grand jury secrecy, but are governed by Rule 6E6, which requires that, quote, records, orders, and subpoenas relating to grand jury proceedings must be kept under seal to the extent and as long as necessary to prevent the unauthorized disclosure of a matter occurring before a grand jury, end quote. Emphasis added. Although Rule 6E6 displaces any First Amendment or common law right of access to documents in ancillary proceedings, see Dow Jones 1, 142 F.3D at 500-04, the rule allows for their release once sealing them is no longer necessary to protect grand jury secrets. In assessing the extent of such necessity, the Circuit has explained that Rule 6E6's reference to, quote, a matter occurring before a grand jury, end quote, protects, quote, not only what has occurred and what is occurring, but also what is likely to occur, end quote, before that body, Ibid at 500. The rule, therefore, protects information in ancillary documents that reveals, quote, the identities of witnesses or jurors, the substance of testimony, as well as actual transcripts, the strategy or direction of the investigation, the deliberations or questions of jurors, and the like, end quote. Ibid, quoting SEC v. Dresser Indus Incorporated, 628 F.2D 1368-1382, D.C. Circuit, 1980. Rule 6E6 protection certainly, quote, does not create a type of secrecy which is waived, end quote, as soon as, quote, public disclosure occurs, end quote, but once, quote, information is sufficiently widely known, it has lost its character as Rule 6E material, end quote. Ibid at 505, quoting in Re North, 16 F.3D 1234, 1245, D.C. Circuit, 1994. The rule's secrecy requirements therefore yield only, quote, when there is no secrecy left to protect, end quote. In Re Grand Jury Subpoena Judith Miller, Miller 2, 493 F.3D 152154, D.C. Circuit, 2007. Citation omitted. As the government acknowledges, courts have found the protection to yield in two circumstances. C. ECF number 5-1, Government Opposition at 10 to 11. In re. Press Application for Access to Judicial Records and Procedures, Miscellaneous number 22-128. 2023 U.S. District Lexus 104648 at 4 DDC March 11, 2023. The first and most common occurs where a grand jury witness has herself disclosed facts surrounding her own grand jury testimony. See Dow Jones 1, 142 F.3d at 497-99, 505. Holding court could not deny request for ancillary documents on sole ground that disclosure would reveal identity of subpoenaed witness, where witness's attorney had already, quote, proclaimed from the rooftops that his client had been subpoenaed, end quote. In re. Press Application for Access to Judicial Records ancillary to certain grand jury proceedings concerning former Vice President Pence. Miscellaneous number 23-35, 2023 WL 3931384 at 4 DDC June 9, 2023. Disclosing records concerning grand jury witnesses' privilege dispute were his own, quote, public statements disclosed, end quote, the existence and resolution of the dispute. Second, disclosure may be permitted where once protected information has already been disclosed by way of a judicial or other governmental proceeding. See in re. North 16 F.3d 1234 1244 245 D.C. Circuit 1994. Permitting disclosure after prior judicially authorized release of independent counsel reports revealed certain grand jury matters, citing what is now Federal Rules of Criminal Procedure 6E3E1. Miller 2, 493 F.3d at 154, releasing, quote, grand jury matters revealed either during the resulting trial or by grand jury witnesses themselves, end quote. Once it has been determined that, quote, continued secrecy is not necessary to prevent disclosure of matters occurring before the grand jury, end quote, Local Criminal Rule 6.1 affords some discretion in how and when to release such records. See in re. Press Application concerning Pence, 2023 WL 3931384 at 6. This court and its predecessor have recently applied these principles to 3 requests for documents concerning Special Counsel Jack Smith's investigations of Trump. First, then Chief Judge Beryl Howell rejected a request for filings and transcripts concerning, quote, Trump's privilege challenge, end quote, in a separate grand jury investigation concerning interference with the certification of the 2020 presidential election results. In re. New York Times Co., Miscellaneous number 22-100, 2023 WL 2185826 at 1 and 2. DDC, February 23, 2023. Judge Howell explained that even partially granting the request would inevitably disclose grand jury material that retained Rule 6E6 protection, because the only public reporting on the existence of any privilege dispute relied on unnamed sources rather than, quote, the type of confirmation by government attorneys, grand jury witnesses, or a privilege holder that the circuit has found sufficient to make secrecy no longer necessary, end quote. Ibid at 14. Less than a month later, and on the same grounds, she declined a press request for records related to a contempt proceeding against Trump in the same classified documents investigation at issue here. See in re. Press Application for Access to Judicial Records and Proceedings, 2023 U.S. District Lexus 104648 at 7. Emphasizing that existence of any contempt proceeding had been disclosed only by, quote, news articles derived from anonymous sources, end quote. Third and most recently, this court granted in part a request to release records concerning former Vice President Michael R. Pence's constitutional challenge to a grand jury subpoena in the election interference case, after Pence himself, quote, virtually proclaimed from the rooftops, end quote, that he had lodged and partially lost such a challenge and would testify before the grand jury. In re. Press Application concerning Pence, 2023 WL 3931384 at 8, quoting Dow Jones 1, 142 F.3d at 505. It is against this backdrop that the Court analyzes the current dispute. 3. Analysis. This time around, the press requests documents concerning a privilege dispute that it surmises must have occurred. It assumes both that Trump and Attorney 1 must have invoked the attorney-client privilege regarding their communications, and that Judge Howell must have found that an exception, e.g., crime fraud, vitiated such privilege. Yet were this court to release or deny the existence of records relating to such dispute, it would necessarily also confirm or deny whether a witness was indeed called to testify to and invoked that privilege before the grand jury. See Dow Jones 142 F.3d at 501. Quote, the fact that a witness was subpoenaed to testify and the fact that he invoked the privilege in response to questions would be, according to the court's precedent, matters occurring before the grand jury. End quote. Quoting SEC v. Dresser Industries, Inc., 628 F.2d 1368-1382, D.C. Circuit, 1980. In re New York Times Co., 2023, WL 2185826 at 13, quote, materials concerning privileges asserted to withhold testimony are also matters occurring before the grand jury, end quote. The press appears to concede this point, but maintains that it is, quote, no longer necessary, end quote, to keep the existence of any such dispute secret, because the media has already reported that Corcoran invoked the privilege and because the indictment contains attorney-client communications. See Federal Rules of Criminal Procedure 6E6, Memorandum at 8 to 9. In making this argument, the press infers that Corcoran declined to testify before the grand jury, that he was compelled to do so, and that his resulting testimony revealed the communications with Trump that now appear in the indictment. Each step is rooted in conjecture, and none justifies revealing grand jury secrets. The press walks the court down the following path. It starts with the March 2023 reporting as having revealed that Corcoran invoked the attorney-client privilege before the grand jury earlier this year. See Memorandum at 1 to 2. The press then notes that the indictment contains extensive evidence of Attorney 1's communications with Trump, plugs in its inference that Attorney 1 is Corcoran, and concludes that Corcoran must have been made to testify before the grand jury about his conversations with Trump after his attempt to invoke the attorney-client privilege back in March fell flat. While they make for an interesting trip, these suppositions do not rely on any actual statement by a grand jury witness or any other formal government disclosure. Begin with media reports that Corcoran invoked the attorney-client privilege before the grand jury. That account was based on unidentified sources of the same kind that this court's predecessor has twice explained cannot strip grand jury material of its Rule 6e protection. See in re New York Times Co., 2023, WL 2185826 at 14. Quote, those sources, however, are not the type of confirmation by government attorneys, grand jury witnesses, or a privilege holder that the circuit has found sufficient to make secrecy no longer necessary. End quote. Citing Dow Jones 142 F.3d at 505. In re Press Application for Access to Judicial Records and Proceedings, 2023 U.S. District Lexus 104648 at 4, quote, petitioner's citation to news articles derived from anonymous sources is unpersuasive because, under binding case law, such reporting does not erode grand jury secrecy, end quote. Cleaned up. Here, as in those cases, both the purported witness and the government understandably and expressly declined to comment on that reporting. See Dawsey et al. Supra, Falders et al. Supra, in Re North 16 F.3d at 1245, quote, when the media reports information alleged to be grand jury material, the government is obligated to stand silent and not confirm the information, whether it is accurate or not, end quote. Quoting Berry v. United States, 740 F. Supplement 888891 DDC 1990. The only identifiable individual who may have had some direct knowledge and who commented on that reporting is Trump, the target of the investigation. Although statements made by the holder of the privilege could be considered relevant, Trump's statements called the reporting, quote, fake news, end quote, and suggested at most that the grand jury sought to learn what his attorneys knew, not necessarily that it asked for their accounts of their communications with him or that any such effort was successful. See Falders et al. Supra, Dawsey et al. Supra. The court declines to read more into those statements. Nor has the June indictment confirmed those anonymous reports. The press surmises that the indictment, quote, undoubtedly, end quote, reveals that the government obtained attorneys 1 and 2's communications directly from them and over their invocation of the attorney-client privilege. See Application at 1 because it recounts the attorney's communications with Trump in such detail. See Memorandum at 6. That may be true, but it is ultimately only one of several plausible inferences that may be drawn from the indictment. The government is correct to point out that the indictment, quote, demonstrates only that it obtained these communications, not through what means, in what form, or from whom, end quote. Opposition at 14, listing as alternative possibilities Trump's waiver of the privilege or external sources. Indeed, the press's application underscores that disclosure by this court would reveal inner workings of the grand jury's process that are not already public. It emphasizes that the public, quote, has been left in the dark as to how the government could have successfully obtained, end quote, records of these attorneys' communications with Trump, quote, given the customarily robust protections of attorney-client privilege and or the attorney work product doctrine, end quote. Memorandum at 2. See also IBID at 7, similar. Revealing the particulars or outcome of any such dispute would therefore necessarily reveal whether the grand jury sought and ultimately obtained testimony from particular attorneys and on what basis. The press attempts to analogize to 2 recent releases of records relating to ancillary grand jury proceedings, but neither moves the needle. See Memorandum at 9. The first is Judge Howell's release of a redacted 2017 opinion requiring Paul Manafort's attorney to testify before a grand jury despite an attorney-client privilege claim. See in Re-Grand Jury Investigation, Miscellaneous Number 17-2336, 2017 WL 489-8143 at 1, DDC October 2, 2017. As the government explains, the rationale for that publication decision remains sealed to the public. See Opposition at 19. In the one sentence in its memorandum devoted to the release of this 2017 opinion, the press appears to imply that Judge Howell released that opinion solely because an indictment had been issued following the grand jury's investigation. See Memorandum at 9. The argument appears to be that since Judge Howell released a redacted opinion on a grand jury witness's attorney-client privilege dispute after an indictment in that case was issued, the court should do the same here. As Judge Howell's decision to redact parts of that opinion even after publication of the indictment illustrates, however, see Unsealed Opinions in Sealed Cases, U.S. District Court for D.C., https://perma.cc/W6pp-7LLJ, last visited August 18, 2023. IBID, Memorandum Opinion, redacted. https://perma.cc/AN5W-BPSS, October 2, 2017. The publication of an indictment does not automatically vitiate Rule 6e's protections. This court must still assess whether the specific facts disclosed in an indictment render it, quote, no longer necessary, end quote, to protect a particular grand jury secret. See Federal Rules of Criminal Procedure 6E6. In Judith Miller 2, for example, the circuit released only parts of its opinion resolving an ancillary dispute, even after issuance of an indictment, and it then waited to release additional portions of that opinion after the criminal trial, in which grand jury witnesses had revealed the specific secrets implicated in those portions. See 493 F.3d at 153-155. Here, as the indictment leaves undisclosed how the government obtained information about Trump's communications with his attorneys, revealing the existence of an ancillary privilege dispute would necessarily reveal a still secret matter before the grand jury. The press also cites this court's recent release of records related to Pence's constitutional challenge to a grand jury subpoena in the election interference case. See In Re Press App Concerning Pence, 2023 WL 3931384 at 6. There, however, the grand jury witness had himself revealed the existence and outcome of the ancillary privilege dispute, such that the court's release of redacted records related to it disclosed only additional legal details about the reasoning it employed. See Ibid. The press finally appeals to what it perceives as this court's discretion to grant its application, citing for support to cases applying the First Amendment and the common law right of access to judicial records. See Memorandum at 2.8. Citing MetLife, Inc. v. Financial Stability Oversight Council, 865 F.3d 661-675, D.C. Circuit, 2017. And Richmond Newspapers, Inc. v. Virginia, 448 U.S. 555-572, 1980. There is, however, no such, quote, right of access to documents in ancillary proceedings, end quote, regardless of how newsworthy and significant such proceedings may be. In Re Press Application Concerning Pence, 2023 WL 3931384 at 3, citing Dow Jones 142 F.3d at 500204. See also in Re New York Times Co. 2023 WL 2185826 at 14. Quote, historical significance alone is not enough to disclose grand jury material, end quote. Rule 6E is the lodestar here, and the court has discretion to supplement, but not to circumvent, its requirements. See Local Criminal Rules 6.1, permitting the disclosure only upon, quote, finding that continued secrecy is not necessary to prevent disclosure of matters occurring before the grand jury, end quote. That is for good reason. As our circuit has explained, quote, there is likely to be a chilling effect on what a witness is willing to say to a grand jury, end quote, including whether and how she may invoke a testimonial privilege, quote, if there is a risk the court will later make the witness's testimony public, end quote, based on the revelations of others. McKeever, 920 F.3d at 849, citing Douglas Oil, 441 U.S. at 219. While the court appreciates the press's diligent efforts to inform the public of the details surrounding these newsworthy events, it is constrained to neither confirm nor deny the existence of the records the press seeks at this time. 4. Conclusion. For the foregoing reasons, the court will deny the press's application. A separate order so stating will issue this day. Signed, James E. Boasberg, Chief Judge. Date, August 18th, 2023. This concludes this episode of The Docket. I hope you enjoyed this audio version of Special Counsel Smith's response. For updates on The Docket, please visit docketpod.com or find us on Threads and Instagram as DocketPod. Please consider subscribing to The Docket and supporting my Patreon at patreon.com/docketpod. Thank you.